Hi, everyone. My name is Rebecca Lee. I'm the Executive Director of Vivli, and I'm really delighted to introduce our webinar topic for today, recent developments in data privacy laws and how they impact data sharing. David and Catherine, if you could turn on your video. We'll send a link to the recording and slides for everyone who's here today. And we would ask that you post your questions in the Q&A function. We'll try to get to most of the questions today. All of you will be muted for the duration of the presentation. I'm really delighted to introduce our two presenters today, David Pelequin and Catherine Wong, who are both partners at Ropes & Gray. Ropes has been a longtime partner of Vivli, and we're really happy to introduce the topic and have an interactive presentation today. So again, please put your questions in the Q&A, and David and Catherine will be happy to answer most of the questions as we go through. So I'll hand it over to David first, and who'll introduce the topic and introduce both of the speakers. So David, Catherine, hand it over to you.
Thank you for that, Rebecca. It's really a pleasure to be with all of you today. I'm David Pelequin. I'm a partner in the Boston office of Ropes & Gray, and I'm very pleased to be joined by my partner, Catherine Wong, from the Shanghai office of Ropes & Gray. And we're going to be talking today about recent developments in data privacy law and their impact on data sharing. If we go to the next slide, just as some background to this topic, and Catherine and I chose this topic because we both spend a lot of time every day helping sponsors of clinical trials, contract research organizations, and clinical trial sites figure out how to transfer data across borders in their clinical trials. And after giving you some background in this presentation on the state of the law today, we're going to have some examples at the end of the program that'll try to bring this to life with the types of situations that Catherine and I deal with all the time. We're constantly phoning one another to talk about how might a data transfer situation work from a US or an EU or a China perspective. And that, of course, comes about because clinical trials are increasingly multinational. They require the flow of data across international borders. This has been a trend for a long time, but especially we saw in 2022 with FDA calling for multi-regional clinical trials to support applications to the FDA. We'll, of course, see an increasing trend in international transfers of data and clinical trials. Of course, at the same time that we have this internationalization of clinical trials, we also have the proliferation of data privacy laws around the world that often place restrictions on the transfer of data from one jurisdiction to another. Some of those laws are specific to certain types of data. Catherine's going to talk in a little bit about some laws in China that are specific to genetic data. Other laws, though, apply broadly to all personal data, and they restrict the flow of those data out of one country to another unless certain legal permissions are put in place. And we're going to spend quite a bit of time today talking about what are those legal permissions needed to transfer data. It's also important that when you're designing a clinical trial that you don't wait until the last minute to start to think about some of these data transfer issues. Catherine and I have both dealt with situations where the parties hadn't really contemplated the data were going to have to flow across borders. And then when it came time to transfer data, or let's say in the process of a licensing transaction, there was some diligence done about how could data collected in trials be transferred from the licensor to the licensee. All of a sudden, questions were risen about how can we do the transfer? How can we allow the data to flow? And we've had to quickly, in some cases, try to retrofit certain contracts or certain notices to data subjects in order to permit data to flow across international borders. So this is something to think about at the outset of a trial when you're designing in which geographies the trial will take place. Definitely plan out what data transfers are there and how are we going to legitimize those data transfers under data privacy laws. And then, of course, a lot of times people say in the trial context, oh, well, do we really have to worry about this because aren't our clinical trial data all anonymized? So are they even subject to these restrictions? But it's important to keep in mind the difference between anonymized data and pseudonymized data, wherein we'll talk about that distinction, where data that are fully anonymized are no longer subject to data privacy laws. They're not subject to these restrictions. And Vivli is a good example there, and that Vivli requires that all data placed on the platform, be anonymized to the standards set forth in GDPR and other international privacy law. And that's why some of you might be thinking like, well, why haven't these issues come up when we've been transferring data to Vivli? However, a lot of data in clinical trials are really pseudonymized, not fully anonymized, and so they're coded data, and they remain subject to data privacy laws in most instances. And we'll talk about that distinction as we go through the presentation today. So if we could go to our next slide, Julie, we'll see on our agenda, we're going to start with a little refresher of the EU GDPR, which was really the first one of these major privacy laws around the world to have restrictions on international transfers of data. And then I'm going to turn it over to Catherine, and she's going to focus on the PIPL, China's privacy law that took effect at the end of 2021. And she'll have some in-depth discussion of what does that law require, and that might be new for many of you. Then we're going to talk about cross-border transfers of data under GDPR. There's some very recent developments in that space, in particular with transfers from the EU to the US that we'll talk about. And then Catherine's going to talk about some PIPL challenges with cross-border transfers of data. And at the end, both of us are going to walk through a few common scenarios. But before I go on, I'm going to ask Catherine, did you have any introductory remarks that you wanted to give before we delve into the presentation?
Well, thank you very much, David, for your thorough overview of the introduction and the context under which we're going to present our respective views on the EU GDPR and the China PIPL. I am a partner in the Shanghai office, as David has just mentioned, so it's a real pleasure and great honor to be able to participate in today's presentation and also share my personal observations of how China's PIPL is going to impact the conduct of multi-regional clinical studies and the sharing of clinical study data on a platform that Vivli has set up. So thank you very much for your time, and I'll let David continue with the presentation.
Thank you, Catherine. Julie, if we could go to our next slide. This is, I think, going to be a review for many people who are on the webinar today. But what we are going to go over now is the basics of the GDPR. And so, of course, I think many of you know at this point that the GDPR is a privacy law that took effect in the European Economic Area back in May 2018. And it regulates the processing of personal data, which is defined as any information relating to an identified or identifiable natural person. And this is a very broad definition that essentially sweeps in anybody who could be identified by their name or an identification number like a social security number, location data, online identifier like an IP address or a cookie identifier, or maybe you don't have any of these traditional identifiers, but if you have information about the person's physical state, their genetic data, or their cultural or social identity, if that would allow you to re-identify the person, those data are considered personal data subject to the law. And GDPR, of course, applies across the economy. It's not just about health data. It applies to personal data of people who might be investigators in a clinical trial, clinical study staff, in addition to clinical trial subjects. All those people's data would be protected under GDPR as personal data. In the context of clinical trials, we often have pseudonymized data, as I mentioned earlier, or key-coded data. And under the GDPR, those data would generally remain personal data if somebody can link those data back to the individual. It doesn't matter that perhaps the sponsor is receiving key-coded data and the sponsor can't link back the data to the individual's name. As long as there's an investigator or clinical trial site that could make that link back to the individual's identity, then those data generally would still be considered to be personal data protected by the GDPR. And of course, one of the reasons that people focus so much on the GDPR is because of the stiff penalties that are found in the law, which can have fines of up to 20 million euros or 4% of annual revenue, whichever is higher. And we saw earlier this year, for example, fines levied against Meta of 390 million euros. So there have been quite significant fines in this space. If we go to our next slide, just a refresher on geography, because I still get a question about like, well, where does the GDPR apply? And so it applies in the countries of the European Economic Area, which are all of the blue countries and the green countries on this map. And those are the blue countries are the European Union, and then Norway, Iceland, and Liechtenstein are the European Economic Area, along with the European Union. Then in Switzerland, the GDPR does not apply. Rather, Switzerland has its own data privacy law. There's substantial amendments to that law that are taking effect later this year that are going to make it more similar to the GDPR, but it remains a separate law. And so when you're dealing with Switzerland, you should consult appropriate counsel about the distinctions with Swiss law. And then the United Kingdom, of course, has Brexited. It's outside of the European Union, outside of the European Economic Area, but then nevertheless, the GDPR continues to apply in the United Kingdom in the form of the UK GDPR, which if we go to our next slide, we have on our next slide just a short discussion of the UK. They have the UK GDPR, which is similar to, it's almost a copy and paste of the EU GDPR. And data can freely flow from Europe to the United Kingdom at present because the European Commission decided that the United Kingdom, despite Brexit, continues to be a country that adequately protects personal data. And that's largely because they've adopted the EU GDPR into their national law in the form of the UK GDPR. And so when you're dealing with the UK, you should think of it largely as being the same as the European Economic Area when it comes to data privacy. And there's one distinction for data transfers that we'll talk about later on, where there's some different contract language that might be used if you're dealing with the UK in addition to or as opposed to the European Economic Area. If we go to our next slide, one of the things that was really unique about GDPR, and we'll see that this has been echoed now in PIPL, is the idea of having some extraterritorial applicability. The idea being that, well, if this law only applied within European Union member states, it wouldn't help when data of Europeans is sent abroad if those data were no longer protected. And so that's the idea that the GDPR should apply not only within Europe, but also extraterritorially in some cases. And so specifically, the GDPR will apply if one of three things is true. First, if an entity is established in the European Economic Area and processes data in the context of the establishment, then the GDPR will apply. So let's imagine that you are a sponsor of a clinical trial and you have a location in France, which is your headquarters, and you do all of your analysis of trial data there. Then the data that you process in France, in the context of that establishment, as it would be called in GDPR, is subject to GDPR. Even if those data originate in the United States or South America or China, if you're processing them in France in the context of your establishment, then GDPR is going to apply. Then with respect to people who aren't established in Europe, let's say you're a company that's based in Boston, where I live, you have no physical presence in Europe. Could you be subject to GDPR? Well, you might be subject to GDPR if you are processing personal data in relation to offering goods or services to people who are located in the European Economic Area. So let's say you're a company based in Boston and you offer a mobile application that's available on the Apple Store in Europe. In that case, you're offering a good or service, i.e. the app, to people who are located in Europe, and the GDPR would apply to your processing of data that you obtain through the app from people who are located in Europe. That doesn't mean that all of your data processing becomes subject to GDPR. Let's say you process data of your employees here in Massachusetts, that wouldn't be subject to GDPR. You process data of US users of the app, that probably wouldn't be subject to GDPR. But if you're making the app available to people located in Europe and processing their data, that then would be subject to GDPR. The GDPR also applies if we look at this third bucket, if an entity processes personal data in relation to monitoring the behavior of individuals in the European Economic Area. What does monitoring behavior mean? If you read the text of the GDPR in the recitals, it talks about how monitoring behavior can mean tracking somebody's use of the internet over time through cookies and pixels. So online tracking is definitely monitoring behavior. But also the European Data Protection Board has told us monitoring behavior can be regular reporting on somebody's health status. So for example, if you think about a clinical trial where you have regular reporting on an individual's health status, that's likely to be considered monitoring behavior. And so if you're a company based in Boston, you're sponsoring a trial taking place in Europe, and you are receiving regular reports of somebody's health data through that trial, even in pseudonymized format, if you're getting regular reports of health data on the case report forms, that could be considered monitoring behavior. If we go to our next slide, we will see there's certain requirements that apply. We see GDPR is agnostic as to the citizenship or residency of the data subject, I should note. So GDPR doesn't care if people live in the United States, if their data are processed in Europe by a sponsor, let's say established in Europe, those data would be subject to GDPR. Or if, for example, in my app example, we were making the app available to people in Europe, and those people in Europe were US citizens, that wouldn't matter for purposes of the applicability of GDPR. Conversely, if you have European citizens who come over and work at your company in the US, those people their data would not be subject to GDPR. If they've moved to the United States and they're working at your company here, it doesn't matter that they're an EU citizen because they wouldn't fall within these jurisdictional hooks. And I think we have a question about this in the chat. Which says, does this mean that data about US data subjects that is made available to European researchers needs to comply with GDPR as well? And generally, the answer is that if you are established in Europe, so let's say you're a European university, and you're processing personal data of US data subjects, you generally would need to comply with the GDPR because you, the European university, fit within this first bucket here. You're established in Europe and processing personal data in the context of your establishment in Europe. And there's also one other question from the same questioner that I'll address now that says, for data from the US, does Vivli require data be anonymized or can data be de-identified under the HIPAA safe harbor? And generally, the Vivli requirement is that data be anonymized. Of course, you could look to the de-identification safe harbor under HIPAA when thinking about whether data are anonymized. That might be one approach that you take, but generally the data need to be anonymized to the standards set forth in GDPR. If we go to our next slide, the GDPR, this is a good segue because GDPR provides that anonymous data are no longer subject to the law, and thus they're not subject to the regulation. And as I mentioned earlier, anonymization is not the same as pseudonymization. Anonymization is judged on a facts and circumstances basis, taking into account all the means reasonably likely to be used, such as singling out either by the controller or by another person to identify the natural person directly or indirectly. Now, this assessment of anonymization requires taking into account all objective factors when assessing whether the data are capable of re-identification. And this includes the costs of and the amount of time required to identify the data and the available technology and technological developments at time of processing. So it's not a static assessment. Data could be anonymized today, but it's possible that tomorrow there might be new technologies that would render those data identifiable. And so that's something to think about. The European Data Protection Board guidance on anonymization tells us that it's difficult to achieve. It should be approached with caution in the context of scientific research, especially when genetic data are involved. And the European Data Protection Board has said that it remains unresolved whether any combination of measures could make genetic data anonymous. And so they haven't gone on record, and the European Data Protection Board, I should say, is the body within Europe that issues guidance on GDPR. They haven't gone on record to say that genetic data can never be anonymized, but they said that it's an unresolved question at this point in their mind. And it's something on which we do expect additional guidance from the European Data Protection Board later this year. Although we've been waiting for this guidance for the last few years, they keep saying that it will be issued later in the year and then it gets pushed to the next year. So we'll see when this actually issues. If we go to our next slide, we'll see that under GDPR, you've heard me use the word controller. You've probably heard about controllers versus processors and are wondering what do those terms exactly mean? Well, a controller is the entity that alone or jointly with others determines the purposes and means of processing personal data. And examples of controllers are clinical study sponsors, clinical study sites in some cases can be controllers, licensees in a data transaction, let's say, or like a licensing transaction. If you're a company that's licensing a compound to another company, and that licensee is getting clinical trial data as part of the transaction, that licensee is probably going to be a controller with respect to its own use of the data after it receives them. And also like a manufacturer of a drug or device that collects adverse event reports, they would typically be a controller with respect to those reports. If two or more parties work together to determine the purposes and means of processing, they can be joint controllers. This sometimes happens in, let's say, joint development agreements where two companies jointly agree on the development of a product. Processors are entities that process personal data only on behalf of the controller. And so examples of processors are CROs, contract research organizations, central laboratories are frequently processors, data storage companies like cloud service providers, and some clinical study sites. And the reason clinical study sites are listed both under the controller bucket and under the processor bucket is because clinical study sites in Europe take different positions depending on which country they're in about whether they're a controller or a processor. And that's because it's unresolved. I think there's a debate intellectually about, well, is the site somebody who is involved in determining the purposes and means of the processing? Well, maybe, because the physician who's an investigator is typically a licensed professional. They have certain obligations to exercise professional discretion when doing the trial. They can't just merely follow the protocol. But on the other hand, you could also think of the sites as processors in some ways, because in a sponsored clinical trial, they're often just carrying out the protocol according to the instructions of the sponsor. So that's a bit of an unresolved issue. And you'll see some countries like the United Kingdom and France, where sites are usually treated as processors, and others like Germany, where they're often asserting themselves as controllers. And that, what does that mean practically? It affects the type of contract that you need in place with the site. Because controllers have to bind their processors to specific data protection agreements that meet specific requirements. And so you'll have to have one of those agreements in place if your site is a processor. If we go to our next slide, we'll see that GDPR imposes several obligations on the controller. So controllers typically have more obligations under the law than the processor. The processor is directly regulated by the law, but they just follow the instructions of the controller, and they're bound by contract to certain duties they have to carry out vis-a-vis the controller. Or the controller, on the other hand, has to meet all the obligations listed on this slide, like establishing a basis for processing, such as obtaining consent of the data subject, or relying on their legitimate interest to process data, falling within an exception for processing special categories of personal data, and special categories of personal data are sensitive data, like health data, for example. If you're going to process those data, you need additional permission under GDPR. These types of entities, controllers, also have to provide notice to data subjects and respond to data subjects' exercise of their rights under GDPR, like the right to access data, the right to delete data. And the controllers also have to establish a basis to process or to share data, I should say, to transfer data to third countries outside of the European Economic Area. And we'll talk a little bit more about that later in the presentation. If we go to the next slide, I'll note that if we look at our map here, the GDPR and the UK GDPR both restrict the cross-border transfer of data and essentially say that you need to put in place a legal basis to legitimize the transfer of data unless the destination country has an adequacy decision from the European Commission. And we'll talk about that a little bit later. And so, for example, if you're a research collaborator in Europe who's going to transfer pseudonymized data to the US, they generally need a basis under GDPR to make that transfer. Same thing if we have a US researcher, and this is a good illustration of the principle of when GDPR applies. Let's say we have a US researcher who collects data in the United States. They engage a laboratory in, let's say, Denmark to process samples as part of the research study. So they send all these samples from the US of people who live in the US. They send all those samples to Europe. As I mentioned earlier, when the samples are held by, let's say, our Danish laboratory in Europe, those data that they generate are subject to GDPR in their hands because they're data processed in the context of an establishment in Europe. So when that Danish lab goes to send the results of their analysis back to the United States, that's a restricted transfer under GDPR. There needs to be a legal mechanism to permit the transfer. And we'll talk about that in the second half of this presentation. But I'm going to stop now and turn things over to Catherine, who is going to talk about some basics of the PIPL from China. And I think you'll start to draw in your mind some comparisons between the two laws. So Catherine, over to you. We can go to our next slide. I think we're going to see, yes, my little X here, just showing that these are restricted transfers. And so if we go to our next slide, I will turn it to Catherine.
Yeah, thank you, David, for setting the stage. Actually, after David gave the very thorough overview of GDPR, you'll find that there are some similarities and some differences between PIPL and GDPR. So if we can advance to the next slide. So I wanted to give everyone the correct context of discussing PIPL, because unlike GDPR, which actually aims to protect privacy of data subjects, the whole objective of PIPL is to become an element of China's national security legal regime. If you look at this slide, you'll see a chronological development of the major legislations in this framework. Most recently, we have seen the promulgation of PRC cybersecurity law. And that actually is a hybrid of both cybersecurity and privacy law, because it has some provisions that talk about the protection of personal information, but it's not very in-depth, and it's actually not considered as the framework for privacy law. And fast forward, we have the Human Genetic Resources Regulation and the Biosecurity Law, which is important in a sense that it also has implication on how companies organize and conduct clinical trials, especially with respect to the transfer of clinical trial data out of China. In 2021, Chinese government announced the data security law. Personal information is a form of data, and some types of information could also constitute important data, and its cross-border transfer will be very highly scrutinized by the government. So this is actually a pillar of China's national security framework as well. And the last part of this legal system is actually the personal information protection law. So all these major pieces of legislation actually form the integrated framework and I would say ecosystem of China's national security legal regime. And this is actually important to know, because if we talk about whether the government will exercise control over the cross-border transfer of clinical trial data, it's actually usually reviewed under the lens of national security, not necessarily under the need to protect patient safety or privacy. Let's move on to the next slide. So these four pillars of China's national security framework on data protection and privacy actually share some commonalities and differences. So I use this slide to actually illustrate that some of the data could fall under several legislation, not just one. And not every regulation actually would focus on the same aspect, but they would actually carry different emphasis on the different aspects of data. So for example, if we start with the cybersecurity law, it talks about the operation, construction, and administration of network operators and the networks in China. It has a potential extraterritorial reach. On the data security law, for example, it talks about data processing activities in China. But because it also has extraterritorial reach, when the data processing activities outside China jeopardize national security, public interest, or lawful rights and interests of Chinese citizens, the processing of such data in China could also potentially have an extraterritorial implication. On the biosecurity law, it mainly regulates the cross-border transfer of biological materials and data derived therefrom. So on clinical trial data, for example, if it comes out of the blood samples or urine samples or other biological materials of study subjects, it will be subject to biosecurity law as well. The last piece is the personal information protection law, which mainly applies to processing of personal information in China. But like GDPR, it also has extraterritorial implication under certain circumstances. Let's move to the next slide, please. So the PIPL actually took effect on November 1st of 2021, so a bit over a year. And it actually applies to all data processing activities conducted in China. And that applies to both the Chinese citizens and foreign citizens if their personal information are processed in China. So for example, if a company organizes multi-regional clinical trials and consolidate the analysis of PK data in China for both the European and US and Chinese subjects, that all of the information processed in China will be subject to PIPL, regardless of the citizenship of the study subjects. And PIPL, like GDPR, applies to living individuals. So if the study subjects are deceased, then PIPL no longer apply. It actually, we're talking about extraterritorial reach of PIPL. So let's actually move on to the next slide to give you an example of under what conditions the extraterritorial reach topic would surface. Oh, sorry. So let me actually stop here to talk about the extraterritorial reach. If we can go back to the previous slide, please. Yeah, so in situations where a company outside of China is trying to offer products or services to the citizens in China, then the processing activities of Chinese data subjects outside of China will be subject to PIPL. So this is quite similar to GDPR. Another similarity is if the personal data processor outside of China is trying to monitor or analyze the behavior of Chinese data subjects, then the PIPL would also apply. There are other situations under Chinese law and regulations where the government intends to regulate activities of processing patient information or study subjects information outside of China. Then the PIPL would also apply extraterritorially. So those situations actually are quite similar to the explanation that David just gave under GDPR. So let's move to the next slide, please. So when we talk about the processing activities and to establish the legitimacy of such activity under PIPL, we need to basically focus on three key elements. The first one is we need to find a lawful basis of processing the personal information of the data subjects. And then we need to give notice to the data subjects and respond to their subjects' rights. And the last one is for certain statutory prerequisites that will be required for cross-border data transfer. We need to meet one of the several prerequisites in order to legitimize the cross-border data transfer activities. So only when all three elements are present and successfully met, the cross-border transfer of clinical trial data would be considered legal. So let's move on to the next slide, please. So on the first topic about the legal basis for processing personal information, unlike GDPR, which probably heavily relies on legitimate interest as the basis of processing for clinical study sponsors, under PIPL, there are several bases of processing, and the most important and prominent one is consent. So when you talk about processing of study subjects' personal information under PIPL, the most important basis usually is the informed consent of the study subjects. Only when the consent language is not adequate, we will try to look for other alternative safe harbors that would enable the processing activities without consent. For example, if we're talking about certain statutory obligations that a clinical study sponsor must fulfill, that would become a basis of processing personal information, even if the consent language was not very clear or adequate. There are also situations where you may refer to other administrative regulations or laws under Chinese law. So for example, you would think that the HGR regulation and the Biosecurity Law may provide a basis of processing information of study subjects, provided that the sponsors were able to obtain advance approval of the regulatory authorities in China. to justify the collection and preservation of personal information of the study subjects. Another example is the processing of safety incidents. So if you're going to submit adverse event reports, you may have to process the information of the patients, but the patients may not necessarily give the data controller consent. So in that situation, I would also recommend clients to look and use the regulation of Chinese good pharmacovigilance practice or the drug administration law as the basis of processing patients' personal information for the purpose of adverse events monitoring and reporting. So let's turn to the next slide, please. So we talk about cross-border data transfer, and we just identify 3 elements that need to be met when we transfer clinical trial data cross-border. The first one is legal basis of processing. The second one is notice, which is more self-explanatory. The third one is certain statutory prerequisites that the personal information controller needs to meet for one of the several conditions in order to justify its cross-border data transfer activities. So the first prong of the condition is the security review by the Cybersecurity Administration of China. And this is actually a topic that is very relevant and also quite challenging for many of the study sponsors to meet, because actually the criteria applied by the Cybersecurity Administration in China was not very clear. Many companies have applied for security review, but to my understanding, probably none of the pharmaceutical company sponsors has yet to successfully obtain a clearance from the Cybersecurity Administration. The second possibility is to have the recipient outside of China be certified by the CAC's designated institutions. That is also not very feasible in most cases because many of the offshore data controllers or processors would not be very open to share their IT infrastructure with the Chinese government designated agency. So this is, again, not a very helpful condition for the cross-border data transfer activities. The third one is to enter into a data processing agreement with a recipient following China's standard contractual clauses. So this is like the GDPR's SCC. The data controller in China will need to enter into a data processing agreement with the Chinese PIPL standard contractual clauses as a form document to adopt in order to enable the transfer of clinical trial data, for example. And the last one is if you have the other conditions prescribed by law or regulations and you are able to fulfill those conditions, you can also transfer data cross-border. In terms of the data transfer activity, it actually includes the physical transfer as well as remote access. So if the data is stored in a centralized server in China, but people from outside of China would be able to access such data on the server in China, it will still constitute data transfer and will have to meet one of the 4 conditions in order to be considered legal. So let's move on to the next one. So I note that we have a few questions in the Q&A. Are we going to go through the questions now or later?
We could go through them now, Catherine, and I think actually a few of them, we've answered the first 2, and I think the third and fourth ones I'm just about to address in the next part of the presentation. I think I can take those as we go along. One question though, Catherine, you might be able to answer is there's a question about, is PIPL available in English? Any other languages?
Yes, we have actually PIPL translated in some commercial legal databases in English. So we can send the English translation to colleagues in Vivli for further circulation with participants for today's webinar.
Thank you. And then I think if we go to our next slide, we're going to talk about cross-border transfers right now. And that'll answer many of the questions that are in the chat, and I'll take those as we go through them. So cross-border transfers under GDPR, I previewed this in the last slide in our overview of GDPR section. But essentially, Chapter 5 of the GDPR requires that when there has been no adequacy decision from the European Commission with respect to a third country receiving personal data from a European country, then there needs to be a mechanism in place to legitimize the transfer. And that controller or processor that's exporting data from the EU then needs to either put in place appropriate safeguards for the transfer of the data or satisfy the requirements for a derogation from the requirement for appropriate safeguards. And I'll talk in some detail about what the appropriate safeguards are and what derogations are. But this answered one of the questions in the chat, which was, what is an adequacy decision? And essentially, an adequacy decision is a determination by the European Commission that a country outside of Europe has equivalent data protection laws to a country, to those of the European Union. And so countries that have received adequacy decisions from the European Commission to date include those listed here. You'll see a lot of these are small countries that are affiliated with Europe, like Andorra or the Faroe Islands, but there's also some notable countries here for clinical research, including Argentina. Canada has a partial adequacy decision only for commercial organizations that are subject to PIPL, the Canadian privacy law. Japan has an adequacy decision, New Zealand, the Republic of Korea, Switzerland, the UK, and Uruguay. So if you're transferring data to one of these countries, that's not considered a restricted transfer, and you don't need to put in place a mechanism to, legitimize the transfer of data. If we go to our next slide, we will see that there are different ways that you can legitimize the transfer of data if you're sending data to one of the non-adequate countries, like the United States. The US is a non-adequate country. China is a non-adequate country in the eyes of Europe when it comes to data protection. And so you can either put in place appropriate safeguards, and those are listed in Articles 46 and 47 of GDPR. And that includes things like binding corporate rules for intergroup transfers. Essentially, binding corporate rules allow a multinational company that has, let's say, affiliates throughout the world to enter certain data protection standards for the company, and it allows intra-group transfers. So transfers of, let's say, HR data from a large multinational's European office to their US office, let's say. More common, and probably most common, are standard contractual clauses that are approved by the European Commission. And those are form agreements that two parties can enter to allow data to transfer. And this answers, I think, one of our questions in the chat or the Q&A, which said, is there some document available that has the legal language already drafted for transfer of data? And yes, the standard contractual clauses would be those documents, because they're for agreements that allow for the transfers of data from Europe to the US or other countries without an adequacy decision. If the standard contractual clauses don't fit your scenario, there's also the possibility of having bespoke clauses that you make on your own, and bringing those to a supervisory authority in Europe, and having that authority approve them. That would then permit the transfer of data. There's also the concept of codes of conduct, which were the subject of European Data Protection Board guidance last year, that allow basically industry groups to form a code that different companies that are part of the industry group can sign on to, and that then permits the transfer of data. But one thing to know about that is that there haven't been any approved codes to date, and you need to have an enforcement mechanism. So that's kind of a future state. And there's also the possibility for approved certification mechanism, and that's, again, something that hasn't been widely used to date. If you don't have appropriate safeguards, then there's certain derogations, and derogations kind of like an exception to the general rule. And the GDPR has derogations that allow for transfers of data with the explicit consent of the data subject. If the transfer is necessary for performance of a contract between the data subject and the controller, if the processing or the transfer is necessary for the conclusion of a contract entered in the interest of the data subject, if the transfer is necessary for important reasons of public interest, to establish or defend legal claims, or necessary to protect the vital interests of data subjects. And vital interest is really about a life or death situation. So the only time I really see this being used in a clinical research scenario might be like in the case of expanded access or compassionate use, where somebody is desperately ill and they need a product in order to treat that severe illness. So the derogations are the exceptions. They shouldn't become the rule. They should be relied on in narrow circumstances. I'll make one note about explicit consent, which is a derogation. We do see explicit consent relied upon in the clinical research context sometimes as the basis for transfer, but I think that's becoming less common because it's a disfavored basis, because the European Data Protection Board again has said, well, it's a derogation, it should be the exception, it shouldn't become the rule, and so they would prefer that you put in place standard contractual clauses or another means to transfer data. If we go to our next slide, we'll talk a little bit about the standard contractual clauses, because like I said, they're the most widely used means to transfer data from Europe to the US or another third country. The SCCs are standardized. They're pre-approved model data protection clauses that have been issued by the European Commission. They're commonly used for cross-border transfers of personal data in clinical research. And so you might enter standard contractual clauses between clinical trial sites in Europe and a sponsor in the US. And that sponsor in the US, if it transfers data to a CRO or a CRO works on its behalf, the sponsor may also have standard contractual clauses in place with the CRO. The European Commission issued new standard contractual clauses back in June 2021, so almost 2 years ago. And those have had to be used in new contracts since September of 2021. And December 27, 2022, so just a few months ago, was the deadline to update all existing contracts with new SCCs. So if you have any existing contracts with SCCs that haven't been updated yet, you should do that. If we go to the next slide. More about the SCCs. The benefits of the new standard contractual clauses are that you have 4 different modules that fit different scenarios. So you have controller-controller clauses if a controller is transferring to another controller. Let's say in our example of data flowing from a licensor to a licensee in a transaction, that would often be a controller-controller transfer. You have controller processor clauses that might be used, let's say, if a sponsor is transferring data to a CRO. Processor to controller clauses, that might be used if we think back to my example where we had the Danish laboratory that was processing data or samples collected in the United States. In that case, you would have the Danish lab, the processor, enter a processor controller clause with the US sponsor. And there's also processor clauses, and this might come into place in research. Let's say if we have a CRO who's a processor, transfer data to a central lab who's also a processor. The new standard contractual clauses also clarify that the exporter of the data doesn't actually have to be located in Europe. So you might have, for example, a clinical trial sponsor that's established only in the US that use SCCs to transfer data collected at EU clinical trial sites to a CRO that's located in the US. And you might think, well, that's odd because the sponsors labeled the exporter of the data, but they're actually located in the US, not in Europe. How can they be exporting data from Europe? But the idea is that that sponsor is directly subject to GDPR. So when they transfer data to somebody else in the US, that's an onward transfer. And so they're considered an exporter. And that's one of the things that these clauses allow, is they clarify that they can be used for onward transfers within countries outside of Europe. And they also allow additional parties to be added to the contract through a docking clause that's added to that contract. If we go to the next slide, we'll see that I mentioned earlier that when you're dealing with the United Kingdom, you should think of the United Kingdom as essentially being the same as continental Europe when it comes to the GDPR. The one exception being with respect to international transfers, the United Kingdom has its own version of standard contractual clauses that were issued in March of 2022. The first is they have their international data transfer agreement. This is a freestanding agreement. It's much like the standard contractual clauses, but instead of being issued by the European Commission, it's issued by the Information Commissioner's Office, which is the body within the UK that oversees data protection. This can be used when you have a transfer of data from the UK, let's say to the US, you're just dealing with UK data. But because the ICO wanted to be a bit practical, they recognized that in many cases, you might not only be dealing with data from the UK, you might also have data from the EU that are intermingled. And so in that case, the ICO says you can use the European Union standard contractual clauses, so those clauses we just talked about, and you can add this addendum to them, which is the UK addendum to the FCCs. And when you do that, you can use the same document to allow the transfer of data from the UK and from the EU. If we go to our next slide, a few other recent developments in international transfers from the EU. The European Commission almost a year ago in May of 2022 released some helpful FAQs on how to use the new standard contractual clauses. A few that I think are noteworthy for clinical trials are discussed here. First, they talk about whether the new SCCs can be used for transfers that are made to an entity outside of Europe that's directly subject to GDPR. Because remember, I said many entities outside of Europe will be directly subject to GDPR, like a clinical trial sponsor, for example, because they're seen as monitoring behavior of people located in Europe. So they fall within the territorial scope of the law. The FCC FAQs say that actually, no, the FCCs can't be used for transfers to entities whose operations are directly subject to GDPR. And they said that they will issue new clauses that will work for that scenario later this year. However, if we go to our next slide, what does that mean in practice? Well, a sponsor that's located outside of the European Union, like I said, generally is going to be subject to GDPR directly. But the FAQs I just read said, well, you can't use standard contractual clauses in that scenario, technically, because that entity is subject to GDPR that's receiving the data. And the European Data Protection Board has reminded us that just because a party outside of Europe is subject to GDPR, that does not eliminate the need for a transfer mechanism. And so taken to its logical conclusion, this makes it very difficult for entities to transfer data, because it says essentially if you're directly subject to GDPR, you can't rely on SCCs. But oh, by the way, just because you're directly subject to GDPR doesn't mean that you can avoid needing a basis to transfer data. And I give an example here from this guidance from the European Data Protection Board, where we have a company that's a controller without an establishment in Europe that offers goods and services in the EU. They hire a processor in France to process data on their behalf. When that processor transmits the data to the company outside of the EU, that is a restricted transfer, and you need a basis for the transfer. So in practice, what I will say is that people are using FCCs even when they're transferring data to a company directly subject to GDPR, just often because there's no alternative that is available in that case. But I make you aware of this because some people may raise this question saying like, well, can we really use FCCs because we're transferring data to a company directly subject to GDPR? If we go to our next slide, we'll see that the FAQs, the same FAQs from the European Commission that I was just talking about, they also have some helpful language on onward transfers to regulatory agencies. Because one question that comes up sometimes is, well, we've received data in the US pursuant to standard contractual clauses, but now we need to share some of this data with the US FDA or another government agency in the US, and that US government agency is unlikely to sign SCCs. Can we actually make that transfer? And fortunately, these FAQs that were issued by the European Commission say that a recipient of data can disclose information as part of domestic, administrative, regulatory, or judicial proceedings. And one example they give is a pharmaceutical company that needs to share data with a domestic regulatory authority in order to obtain approval of its product. And so in short, you could make a transfer to FDA without binding them to standard contractual clauses. If we go to our next slide, I'll talk briefly about, in addition to SCCs, SCCs may not be enough to transfer data under GDPR because of the Schrems II decision, which was a decision of the Court of Justice of the European Union that essentially said that the transfers to countries like the US, where there's national security laws that may give the government access to data, they say in those cases the SCCs may not be sufficient to permit the transfer of data on their own. And so they require something called a data transfer impact assessment, which is an exercise in which the exporter of data needs to assess the laws of a third country to which they're transferring data to identify whether they adequately protect data, and if not, to put in place supplementary measures. And there's guidance from the European Data Protection Board from June of 2021 that talks about how you do the data transfer impact assessment. They say first you select your transfer tool, like standard contractual clauses. Then you look at whether a third country's laws may impinge on the effectiveness of the transfer tools, because perhaps even though you have an SCC in place, the laws of the recipient country would allow access to the data. In which case, if that's the case, you can transfer the data only if you put in place supplementary measures necessary to ensure essentially equivalent data protection. And this is something Catherine and I have done a lot, where we've assessed the laws of the US or the laws of China to determine whether they would impinge on the effectiveness of the EU standard contractual clauses. And frequently you would determine that they do, and then you have to put in place a supplementary measure. And so then the question becomes, well, what are those supplementary measures? And if we go to our next slide, we'll see that the European Data Protection Board tells us that pseudonymization is an example of supplementary measures that can be effective. And this is, of course, one that's commonly used in the research community already. And you can use pseudonymization if personal data can no longer be attributed to a specific data subject, if the key to the data is held in the European Economic Area or a third country with an adequacy decision, and you have technical or organizational safeguards to prevent unauthorized disclosure of data, and public authorities don't have access to the key. So if we think about a transfer to the US, if the key needed to re-identify the data stays in Europe, and we say, well, let's say in the United States, one of the concerns of Europeans is that the National Security Agency may access the data. Well, if it's the case that the key is in Europe, we might say, well, even if the National Security Agency accessed these pseudonymized data, so on our slide, if they access code 10001 or 10002, they wouldn't be able to link it back to the individual's name because they lack that key. So pseudonymization is often a helpful supplementary measure. If we go to our next slide, we'll see there are also some additional supplementary measures you put in place, like end-to-end encryption, additional contractual commitments like notification in the event the data are accessed, obligations to challenge data requests, certificates of confidentiality, which some of you might be familiar with, which are a tool under US law to restrict access to research data, and also separating personal data and research results summaries. If we go to our next slide, I talked about the derogations already, that if there's no adequacy decision or appropriate safeguards, you can transfer data if you have the explicit consent of the data subject. And you have to inform them that their data are being transferred from safe Europe to Wild West US, where they may not be adequately protected. But this, again, like I said, should be the exception and not the rule. And the guidance suggests this shouldn't be used if you have repetitive transfers. Although we still see consent used sometimes in the research scenario where, let's say, a party is unwilling to enter standard contractual clauses. If we go to our next slide, it's important to remember that when you're transferring data internationally, even if you have standard contractual clauses in place, you have to inform the data subject of the transfer. And that comes from the transparency obligations under GDPR in Articles 13 and 14 that essentially say, where personal data relating to a data subject are collected from the data subject, the controller shall, at the time that the personal data are obtained, provide the data subject, which could be a clinical trial subject or a clinical trial investigator, with the following information. And one of those elements is, where applicable, the fact that you intend to transfer personal data to a third country, and the existence or absence of an adequacy decision by the Commission. So if you're transferring data from Europe to the US as part of a trial, you would say we intend to transfer data to where the sponsor is located, which is the United States. The US doesn't have an adequacy decision, but we're entering standard contractual clauses to ensure the data are safeguarded following the transfer. And if we go to the next slide, I'm going to round out this section of the presentation by talking about some recent developments. So you may have heard in the news, there's a transatlantic data privacy framework that was announced in March of 2022. And the idea here is to reinstate essentially the privacy shield, which was in place before 2020, and which was a mechanism by which US companies could self-certify that they meet certain privacy standards, and therefore were like a safe haven of data in the US, so the data could freely flow from Europe to those companies that had self-certified to the privacy shield. The Privacy Shield was struck down in 2020 by the Court of Justice of the European Union. So this transatlantic data privacy framework is an attempt by the EU and US governments to remedy the deficiencies found in the Schrems II case, in which the Court of Justice of the European Union struck down the Privacy Shield and put back in place the Privacy Shield. And so what happened last March was an agreement in principle between the US government and the European Commission on a framework for transatlantic data sharing. The idea was there'd be a new US Data Protection Review Court to address complaints of Europeans on access to data by the US intelligence community. Because one of the critiques of the US is that we have access of data by intelligence authorities and Europeans don't have a right of redress. They can't challenge those access by the US government. Also, there would be a limitation on the use of certain intelligence signals by the US government, and companies would be required to adhere to the Privacy Shield principle. If we go to our next slide, benefits of this framework, and I have to say this is a proposed framework, it's not yet been finalized. Benefits for, I think, the research enterprise would be that it's intended to be an adequacy decision, a partial adequacy decision for the US. And so companies that self-certify the Privacy Shield wouldn't need standard contractual clauses anymore or explicit consent of the data subject to receive data from Europe. And transfers of personal data to countries that have adequacy decisions. So let's say companies that self-certified to the Privacy Shield, they wouldn't have to do those data transfer impact assessments that I just talked about. And I just quote some guidance here that makes clear that if a country to which data are transferred has an adequacy decision, then you don't have to do the data transfer impact assessment. You don't have to put in place supplementary measures because the data are already considered adequately protected. However, as I mentioned, if we go to our next slide, we have a bit of a winding road to get to our adequacy decision because the executive order that was issued in October of last year outlined US commitments that would form the basis for an adequacy decision from the European Commission. On December 13 of last year, the European Commission issued a draft adequacy decision implementing the EU-US privacy framework, and that draft decision is then reviewed by the European Data Protection Board and the European Parliament before it's finalized. And so in February of this year, the European Data Protection Board issued an opinion stating essentially that the draft needs more work, this draft EU transatlantic data privacy framework. They said they liked some of the elements of it, but they had concerns on certain points like data subject rights and onward transfers. And they recommended that the adequacy decision be conditioned upon certain policies and procedures that were announced in the executive order last year actually being put in place. If we go to our next slide, we'll see that the European Parliament has been a little bit more negative on this draft adequacy decision. The Committee on Civil Liberties, Justice and Home, the LIBE committee, found that the framework doesn't result in equivalent protection if data are sent to the US. And just about 2 weeks ago, on April 13th, the LIBE committee is likely to endorse a non-binding resolution that urges the European Commission not to endorse the framework until certain of their concerns are fully addressed. And they're probably going to vote on that the week of May 8th. And their concerns, that is the concerns of the European Parliament, are that the Data Protection Review Court's decisions are classified, so the data subject would be denied their rights to access or rectify data. They say there's still not federal privacy legislation in the US, which is true, although we've had a few proposals for that. And they say the executive order is the basis for a lot of the protections, but as we know, executive orders can be rescinded by a future US president, so they don't have the staying power of legislation. And also they noted the executive order doesn't go far enough to limit certain bulk data collection activities they find problematic. Also, the decision needs to be formally adopted by the European Commission before it takes effect and before revised Privacy Shield is available as a mechanism for data transfer. If we go to our next slide, I'm going to turn it back to Catherine, who's going to talk about some challenges for transfer under the PIPL. I see we have a few more questions in the chat, and I might just answer one of them now, because there's a question about all the items that are presented here apply to not only health and clinical studies sector, but also to banking and others. Is that correct? And that's right. What we're talking about today, we're focused on clinical research because we know that's of interest to this audience, but the laws discussed here would apply in other sectors of the economy as well. And I think the other questions we can answer when we go to our scenarios at the end. So I'll turn it to Catherine now to discuss PIPL cross-border challenges.
Sure. So let's move on to the slides. The PIPL has extraterritorial reach, as we just discussed. So we can think of cross-border data transfer under PIPL in a similar way to what David has discussed under GDPR. We have discussed about the legal basis of processing, which is usually based on informed consent of the data subjects. And we talk about one of the several prerequisites that we need to meet in order to legitimately transfer the data cross-border. So if, for example, we have a foreign study sponsor, which is a company located outside of China, and they process study subjects' personal information in China, or they process Chinese study subjects' information outside of China, both may trigger the application of PIPL. So let's turn to the next slide. So we just discussed 3 elements that would justify a cross-border data transfer, and we talk about the legal basis of processing, which is consent. And here we're also talking about notice. So if we think of informed consent form or informed consent documents that sponsors usually rely on to collect and process patients' personal information, that is a consent and also a notice document. So under PIPL, if you want to transfer information outside of China, you need to notify the individual data subjects of the following: the identity of the foreign data recipient, the method of contacting that recipient, the purposes and methods of processing information, and the types of personal information that will be processed. And the last one is how the individual data subjects can exercise his or her rights against the recipient. So this is actually a very extensive and also detailed list of information that needs to be documented and included in the informed consent form. The key question and challenge that a sponsor usually would run into is that once you have multiple data recipients that you were not able to identify at the beginning of the conduct of the trial, over time, you may not actually have the ability again to reconsent study subjects. And for this reason, actually, we try to find a way to balance the PIPL requirements and also balance the operational challenges of running a trial over a longer period of time. So what we typically advise clients to consider is in the informed consent form, trying to I identify all the categories of data recipients that would be able to receive the clinical trial data, but we may not be able to explicitly provide a level of details or specificity that PIPL anticipated. Another issue is PIPL talks about the concept of a separate consent, which is when the data is going to be transferred across the border of China, individual data subjects in a clinical trial will need to give separate consent to such cross-border data transfer. The format of a separate consent was not very well explained in PIPL. In many situations we have seen, including our own advice to clients, we typically would suggest to clients that in the informed consent form, we provide a checkbox for the subjects to check and give explicit consent to the cross-border transfer activities. So let's move on to the next slide. So similar to the data transfer impact assessment that David has introduced, under PIPL, in order to transfer clinical trial data across border, in addition to the notice, to the consent, and also to satisfactory fulfilling one of the prerequisites, you need to perform a personal information protection impact assessment. That's part of a self-risk assessment that a data controller will need to complete before it can transfer the personal information abroad. So this personal information protection impact assessment is relevant when you are handling sensitive personal information. So in a situation where clinical trial data is involved, many of the clinical trial data is considered de-identified sensitive personal information because it's either medical or health information. So when a study, the sponsor or the personal information controller handles such information, even within China, you also need to start putting together this personal impact protection assessment. And when you provide the personal information abroad, then the report is also relevant. This assessment is going to be prepared in writing, and it has to be retained for no less than 3 years. And when the purpose and method of processing has changed, you need to update the personal information protection impact assessment in order to keep it up to date. In this report, the key aspects that you need to address and analyze is what's the purpose and method of processing, whether it is legal, justified, and necessary. You also need to assess what's the impact and security risks to the rights and interests of data subject. And the last one is the protective measures that a data controller is introducing to such information, whether they are legal, effective, and appropriate to reflect the risk level of personal information impact. So let's move on to the next slide, please. So we talk about the concept of a security review, which is one of the prerequisites that a data controller needs to meet in order to transfer the data across border. So there are several triggers for the conduct of a security review, and I have provided them here for your information. The first item is if you transfer important data abroad, then you will have to pass the security review. The notion of important data is actually not very specific. The government has not really provide a detailed guidance on the types of data that will be qualified as important data. In most cases, if the data is going to jeopardize national security, public interest, public health, or the operational order of the economy, it will be considered important. The government has proposed in some draft guidance that certain types of clinical trial data will be considered important if it is, for example, unique to the Chinese patient populations, or it could jeopardize the well-being of Chinese patient population in at large, then the data would be considered important. As of now, because the government hasn't really finalized the data catalog, we haven't actually seen any study sponsors that would be compelled to conduct and seek clearance from the Cybersecurity Administration of China because the data is important in nature. The second potential trigger is if the data controller is considered a critical information infrastructure operator, or if it processes personal information of more than 1 million individuals in China, then it will also require security review and clearance. The most relevant trigger for security review in the context of a clinical trial is the third one. So if you actually process personal information, which is considered regular personal information of over 100,000 individuals, or sensitive personal information of over 10,000 individuals, since the most recent 24 months, which will be calculated from the January 1st of the preceding year until the end of December of the current year. So in any of the 24-month period, if you reach the numeric threshold, you will also need to be subject to security review. And the last one is a catch-all provision. So if there are other conditions or situations dictated by the CAC, that would also trigger the security review requirement. When calculating the number of data subjects, the government actually enacted the cross-border data regulation as of September 1st of last year. So if you transfer data from outside of to outside of China before September 1st of 2022, you are not subject to the security review requirement, but the number of data subjects will need to be cumulatively accounted for when you decide if your follow-on or future data transfer activities will trigger the security review requirement. So let's move on to the next slide. So we talk about the nature of important data, and we also gave some examples on the last bullet point here about what are the potential directions that the Chinese government is going to use to determine which type of data is considered important. So I'm not going to repeat the messages here. Let's move on to the next slide. So this gives you a sense of the processes and the key milestones of the security review. Essentially, it will be a filing made to the Cybersecurity Administration of China, and the agency will conduct the security assessment involving different departments of the government that will have a supervision authority over the industry sector or over the type of data. So this process actually is much longer than what it appears here, because as of today, I think only a handful of companies were successfully in receipt of the security review clearance. Many of the multinational companies have filed for security clearance, but they haven't been able to receive the final result. So let's move on to the next slide. So the PIPL standard contract, we just discussed about the concept in earlier section, and this is similar to the GDPR SEC. The standard contract were recently announced by the Chinese government, and they will become effective as of June 1st of this year. The government provided a 6-month grace period during which the data controller in China and the data recipient outside of China will be able to finalize their standard contractual clauses if they use this as the basis for cross-border data transfer. The standard contractual clauses under PIPL are in Chinese. And if you are going to enter into any supplemental terms, they can supplement, but they cannot replace or they cannot trump the standard contractual clauses that were provided by PIPL SEC itself. So in many cases, we have seen many data controllers in China will ask the data recipient from outside of China to enter into a data processing agreement, especially if there will be bilateral data exchange. In addition to that, the PIPL standard contractual clauses will become an appendix to the main body of the data processing agreement. When you actually transfer data across border, before you actually do so, you have to finalize and execute the PIPL standard contractual clauses. In addition to that, companies will have to prepare the personal information protection impact assessment. Both documents will need to be filed with the Cybersecurity Administration in the province or in the municipality where the data controller is domiciled. So let's move on to the next slide. So we talk about this filing requirement. If you have filed for the data transfer, but you experience any change in the purpose, scope, type, or sensitivity, method, retention period, and the storage location of the personal information transferred overseas, or any change to the purpose and method of processing by the overseas recipient, you will need to apply with the Cybersecurity Administration for an updated PIPIA report. And also, if there are any changes introduced by the overseas recipient on the policies and regulations of the country where the data is going to be destined, that also require an updated filing and the PIPIA. So this has to be updated and also revisited on a regular basis whenever there are changes introduced to the purpose and method of processing personal information or the type and quantity of the personal information transferred abroad, then an update to the PIPIA will be necessary. So let's turn to the next slide, please. So the last one is to have a summary of the key items that will need to be included in the PIPIA report. So this is actually applicable when you apply for security review and clearance, as well as filing for recordation with the Cybersecurity Administration of the Personal Information Protection Law standard contractual clauses. So in both situations, the PIPIA follow a similar framework and structural context. The first item you need to review basically whether the transfer activity itself is legal, legitimate, and necessary. You review the type and quantity of data to be transferred, and then you basically review the responsibility and obligations of the data recipient, especially whether the recipient has introduced adequate organizational and technical measures to ensure security of the personal information of Chinese data subjects. And you also need to evaluate the legal framework of the country of destination, where the local laws and regulations provide adequate and comprehensive protection of personal information. And in situations where there is a security incident, you need to review whether there are enough avenues of the data subjects under the law of the destination to exercise their rights. So once you were able to complete such report, you will have to file the report together with the SECs for record filing, or you basically submit a report as part of your filing for security review and clearance. So let's turn to the next slide.
Thank you, Catherine. And now I think we're going to round things out with some scenarios. And I know we have a number of questions, so we'll try to get to those as well. But kind of to bring it together, we're going to go through a few different scenarios. If we go to our next slide, we have a table of different types of transfer scenarios and whether they're restricted by applicable privacy laws. And if so, how would we legitimize the cross-border transfer in that case? So the first scenario is a transfer from the European Union to the United States. And yes, that would be a restricted transfer. And so we would likely need standard contractual clauses to legitimize it or a derogation. Catherine, I'll let you take the next one.
Yeah, so if you transfer data from China to the US, that's also considered a restricted transfer. So as we discussed, you will need to have the consent of the data subjects, but you also need to have either passed the security review or you put together the standard contractual clauses of PIPL in place to justify the transfer.
Our next two scenarios are both transfers originating in the US, from the US to the EU, or the US to China. Those would not be restricted transfers because the United States does not restrict the transfer of personal data. And so for our first one, US to EU, there's really nothing needed to legitimize it. US to China, there's really nothing needed from a data privacy standpoint to legitimize the transfer. But of course, you'd want to consider other potentially applicable US laws like export control restrictions, and also concerns about foreign influence of China and US research. So there may be other things beside data privacy to consider when transferring data from the US to China. And then from the EU to China, our next one, that would be a restricted transfer, just like the US. So you need standard contractual clauses or a derogation, and likely a data transfer impact assessment as well. And I'll let Catherine take the last one.
Yeah, so if you transfer data from China to the EU, it's also considered restricted under PIPL. So similar to our previous discussion, you need to have the consent of the data subject. If there are no other safe harbors you can rely on, and then you have to either pass the security review or enter into the PIPL standard contractual clauses.
Okay, if we go to our next slide, we'll have a diagram here. Let's say we have a clinical trial site in China. Julie, if you click once, we'll see our arrow come up, and they are transferring data to a CRO in the US. If Julie clicks again, we'll see there's personal data going, and one more click, and we'll see that the data go from the CRO in the US to a lab in the EU. If we click again, we'll see those are personal data. And another click, we see the data go from the lab in the EU to the sponsor in China. And with one more click, we'll see those are personal data as well. So how do we analyze all these transfers? China to US, US to EU, EU to China. If we go to our next slide, we'll talk through it. Catherine, I'll let you start with the China transfers here.
Yeah, so if we can click, we'll have the contents flow out. So we have to first identify which transfers would be restricted in the previous diagram. So the transfer from the China sites to US CRO, they are restricted under PIPL. The transfer from the US CRO to the EU laboratory, it's not restricted under the US law. But the transfer from the EU laboratory to the sponsor in China is again a restricted transfer, but under GDPR.
So Julie, if we click again and one more time, we'll see our options. And Catherine, I'll let you start there.
Yeah. So if we are trying to transfer the information, the personal information from Chinese side to the US CRO, we have to basically get the consent from the data subjects. And we need one of the following conditions that will need to be met. One is either you enter into the standard contractual clauses with the US CRO, or the sponsor in China will have to pass the security review with the cybersecurity administration. And then the sponsor itself will need to run a PIPIA in order to enable the flow of data from the Chinese side to the US CRO.
And now the transfer from the US CRO to the EU laboratory is not restricted, as I mentioned earlier, but when the data are transferred from the EU laboratory to the processor in China, we're going to require standard contractual clauses, likely module 4, processor to controller, because our processor is our EU lab. They're transferring data to China. Remember, it doesn't matter that none of the data subjects here reside in the EU. The fact that the lab is processing data in the context of its establishment would require that there be a mechanism for the lab to legitimize the transfer to China. Alternatively, you could rely on a derogation of explicit consent, that would require obtaining consent for EU-China transfers from Chinese data subjects and warning them of the risk of the transfer from the EU to China that might be difficult. I know we have a number of questions here and only 2 minutes left, so we'll try to go quickly through a few of them. I think the first one is, have there been cases of severe adverse event data from clinical trials being transferred under derogations under GDPR? And I think what you're getting at with this question is like, do you need standard contractual clauses to transfer adverse event data? I mean, typically you would have them in place already between a site where the adverse event could happen and the sponsor in the US. So yes, you would need standard contractual clauses in most cases. You might be able to work through, like, could there be an exception for an unusual circumstance? But usually you'd need something in place to legitimize that transfer. Our next question, I think we actually just answered maybe with this diagram. The question is, if the study is conducted by a US CRO with US patients only, however, the data is transferred to EU and the CRO still has access to the data, there will be a data transfer out of the EU and the parties need SCCs and a TIA. However, the key is in the US. How do you assess the situation in relation to a transfer impact assessment? I think the key here is that if the CRO has the data in Europe, that is, if the data of the US patients is held by a processor in the EU, the processor to controller standard contractual clauses, so from like a EU lab back to a controller in the US, they technically don't require the data transfer impact assessment. That's the one module that doesn't require that. And so you may not actually need to do the TIA there, because I think the concern of this person is that, how do you do a TIA if the key is in the US? The next question is the transatlantic data privacy framework. Is it related to the transatlantic platform? I'm not really sure what the transatlantic platform is, but the transatlantic data privacy framework, if finalized, would allow US companies to self-certify to the Privacy Shield and allow data to flow from the EU to the US. There's a question about how long does the informed consent and notice apply? There's not really, reconsenting later in time is not accepted. There's not really a time limit on how long the notice and informed consent apply, strictly speaking. You want to evaluate that on a case-by-case basis and what's reasonable. There's a question about transfers under the ICMJE requirements, the medical journal requirements that medical journals receive data from a trial in support of a publication. The question is, how do we handle transfers? That's a good question. You have to consider whether the data are fully anonymized that are being shared. If the data aren't fully anonymized, then you likely need standard contractual clauses with the journal or the recipient authors to legitimize that transfer of data. If we go to our next question, I'm going to let Catherine take it. It's about PIPL and anonymized data. Do you see the question, Catherine?
Yeah, I actually saw several questions, so
Yeah.
I'll just maybe not necessarily run one after another, but pick up some of the questions that have a PIPL angle. So the first one is, does PIPL apply to anonymized data as well, or is anonymized data out of scope? It is not within the scope of PIPL if the data is anonymized. So if the data is fully anonymized, it will not be subject to PIPL. It can be transferred freely. But in the context of clinical trial, I think it's probably a bit difficult to fully anonymize the study data. That's why PIPL will still be relevant. Another question is genetic data, whether it constitutes important data and or sensitive PI. It will be considered sensitive PI and will very likely be considered important data according to the latest draft published by the Chinese government. Thinking of PIPL threshold as in relation to clinical trials, they are related to a data controller. So if it's going to be a same sponsor sponsoring several studies and over a period of time reach the numeric threshold, then it will be subject to security review requirement. So that's actually not related to individual trials, it's related to individual data controllers. So the next one on the role of the foreign study sponsor. My understanding is that if the data controller is defined as the foreign study sponsor, then the performance of compliance obligations under PIPL will typically be the responsibility of the local agent of the foreign study sponsor. So when we talk about the security review requirement, one possible interpretation I have heard is that if there is a local agent in China, the local agent may have to fulfill the security review requirement on behalf of the foreign study sponsor. But that may not be consistently adopted across different provincial cybersecurity administration. Another relevant interpretation is that when we talk about the execution of personal information protection laws, SEC, my understanding is, again, the onshore data controller may be interpreted as the local agent of the foreign study sponsor. So the execution of the SEC under PIPL will need to be performed by the local agent, not necessarily by the foreign study sponsor itself. So the security review will probably take actually, I think, a couple of months if we follow the statutory timeline. The problem is many of the companies were not able to actually successfully pass the security review because I think the cybersecurity administration hasn't really formulated a clear criteria or standard to follow consistently in all applications. So that's why for all the applications that the government has received as of March of this year, I think only a handful of them were able to finalize and got the clearance. So if a Chinese subject is visiting a US facility, they will actually be subject to PIPL to the extent that the US facility is offering services to the Chinese patients more generally. So if the Chinese patients voluntarily visit a US healthcare facility, arguably the facility didn't solicit the visit of the Chinese patients and may not be subject to PIPL. But if the US facility actively engages in telemedicine services and attract multiple Chinese patients to come to the US for treatment, then the US facility will likely be subject to PIPL.
And that would be the same analysis for GDPR. And, I think we're 5 minutes over, so maybe we should leave it there, Catherine. I know I have to run, and I suspect many others do as well.
Yeah, so I'm sorry that we are not able to finish all questions, but we can probably respond to them after the webinar. So thank you.
Yeah, thank you so much. I mean, there are a few that I think are really relevant to data sharing, so we will pass them on to you afterwards. I just really want to thank you, David and Catherine, for your time today. I learned so much, and thank you for your wonderful talks. So have a good day. Have a good night, Catherine. I know it's very late for you.
No problem. Thank you.
you,
Bye-bye.
everyone.
Thanks again,
Bye-bye.
and thank you for your attendance.
Bye.
Take care. Bye-bye.